great honor for me to be with you today and to open the discussion about such an important subject. I do recognize some familiar faces and names on the screen, but for those I haven't had a chance to meet yet, I am Sarah Dahmani, the IP attaché of France in the Middle East, and I just moved from Paris and joined the French embassy in Abu Dhabi last January. So before coming to Abu Dhabi, I was the patent examiner specialized in the field of computer science at INPI, which is the French Office of Industrial Property. And having a technical background, I worked in the past in software engineering and computer science research and development fields. And I was also involved in different programs for raising the awareness of French universities and companies about the importance of IP. So now as an IP attaché, my role is to continue supporting the French companies in protecting their IP interests, but this time at a bigger scale on an international level. And I am also eager to work with all of you, with the local stakeholders and authorities to exchange the experience between France and UAE in all fields related to IP. So really happy to join you here in the UAE. And since my arrival, I was really touched by the warm welcome to find such a lovely and dynamic IP community. So thank you all. And I want to thank especially our organizers and partners today, thanks to whom such initiatives exist. So many thanks to the AIPPI, the International Association for the Protection of Intellectual Property, UAE group, to the Gulf BPG, to the EIPA, the Emirates Intellectual Property Association, and of course, last but not least, to the Ministry of Economy for supporting such this initiative and allowing us to discuss such an important topic. So the subject we are discussing today is in the crossroads between IP and employment law, and it is of great importance because, as we know today, UAE is moving toward an economy based on knowledge. So the employees are getting more and more qualified, more and more talented and creative. So this freedom required for creativity needs to coexist with the subordination inherent in the employment contract. So it is important to understand how these IP rights are attributed in this configuration, and what is the legal framework, both in UAE and France, that can be used to distinguish between employer and employee creations. So for that, we are very fortunate to have a distinguished panel of experts who will give us their insights on that complicated matter. So please join me in welcoming our esteemed moderator, Mu'tasim Abu Ghazala. He is a distinguished IP advisor with 30 years of experience in the IP field, so it's impressive. He is specialized in trademark enforcement and law drafting and implementation, particularly across the Middle East, but also on a global scale. Mu'tasim is a prominent figure in the IP community, having held numerous prestigious positions. To cite only a few, he has served as the board director at INPA, INTA, and BPG, and he is a founding and executive board member of the AIPPI UAE group. And he has been recognized with the annual Volunteer Service Award by INTA for his remarkable efforts in the advancement of trademarks law. So this is just a glimpse of many accomplishments. Sorry, Mu'tasim, I couldn't say them all. It would take too long. So we are really fortunate to have you today to guide us through this webinar. So without any further delay, I hand over to you. So please take the lead. Thank you.
Thank you so much, Sarah. That's too much more than what I really deserve, and I'm blushing, as you can see. So thank you so much for the nice introduction. Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillah ar-Rahman ar-Rahim. I'm so happy to be with you today in the last 5 days of Ramadan, which we call the Khams al-Awakhir, which is a very important, maybe the most important 5 days in the year for Muslims in this region. So I'm so happy to be with you. We'll be speaking about a very, very interesting topic that is close to my heart. What can we do? Because what we are seeing now, By the way, I am representing Brand Protection Group in this moderation position, and they are one of the organizers as well. So I've been seeing a lot of patent applications filed recently for local agents with my new firm, although the applicant is a US firm or a Saudi firm or a UAE firm, but the inventors are from different countries. So we are seeing a lot of advancement happening in this direction. There are a lot of inventors doing or participating in patents. And I think this topic would be the most important topic in the coming few years to be able to encourage everyone to be part of this innovation. Before I start, and because it's the holy month of Ramadan, I cannot start without saying from Surah An-Nisa. I'll do this in Arabic because it's much easier for me, please. قال الله تعالى في سورة النساء إن الله يأمركم أن تؤدوا الأمانات إلى أهلها. الأمانات تشمل الأجور والحقوق زي ما احنا بنعرف، ومن أعظم الأمانات التي تؤدى للعامل حقه طبعا. وفي سورة المائدة يا الذين آمنوا أوفوا بالعقود، كمان هاي تتعلق بين العقود والموظفين. فليس هناك يعني أجمل من أن يكون الديانة السماوية كلها تتكلم عن موضوع إعطاء الحقوق. And in this specific topic, we have two distinguished speakers that will be handling this, one from French or European perspective and the one from the Middle East. So without further ado, let me start my introduction with the first speaker for today, Mr. Frédéric Glazy. He's the chair of the Design and Copyright Committee of CNCPI and the co-chair of the Design Committee of the French group of AIPPI. Frédéric leads the design department at Blessard IP, one of the most prominent IP firm in Europe, if not, of course, in France and in Europe as well, where he has been a partner since 2020. He is also a former member of the jury of the professional qualification examination of the French trademark design attorney. He also a regular contributor to legal publication for which he writes on design law. Now, just a few housekeeping comments. So we'll have 15 minutes for the first speaker, and then introducing the next speaker, and we'll present for another 15 minutes, and we'll keep the questions to the last part. We have 10 up to 15 minutes for Q&A. So without further ado, Frédéric, thank you for being with us today. We're so excited to hear what you want to say, and please, the floor is yours.
Thank you so much, Motassem, and thank you so much for having me at BPG here. I'm quite impressed, and please bear with my French accent for the next 15 minutes. I've got a quite long presentation, too long actually, so I may speak a little bit too fast, but please don't hesitate afterward to ask any question. So the topic today is employee creations, who own the IP rights, and I will speak from a French and therefore European perspective. The presentation is divided in three main topics: copyright, designs, and patents. So you don't see trademarks here. Let's say that if an employee creates a trademark, that will go through the copyright perspective. And as regards something as important as software, we will mention it under copyright. So first, maybe the most complex type of right in relation to this topic, copyright. I want to start by stating the most important principle here, that is the creator owns the copyright over his work. That is stated in the very first article of the French IP code, which is quite a long code actually. And the fact that it is mentioned in the very first article is important because there is a notion of hierarchy here. Everything in the code is in a specific order for a specific reason. So the fact that this is the very first sentence of the IP code underlines the importance of the principle. The creator owns the copyright over his personal work. Second principle, if there is a working contract that doesn't, the mere existence of a working contract doesn't affect the first principle. But of course, this is we are in the legal business, and when there's a principle, there are exceptions. So we have exceptions. Before going into these exceptions, one of the things which might influence copyright ownership is also the way that a team will collaborate. When there is only one creator, it's easy. It's the first principle. The creator owns the copyright over his work. Here, if we have several people taking part to the creation of a piece of work, we may have what we call a collaboration work. That is when several natural persons have taken part to the creation. And here, the principle is joint ownership of the copyright. Second possibility, there is what we call the collective work, and this situation will occur when a natural or legal person takes the initiative of the creation and publishes the work. Also, this situation occurs when there is no possibility to attribute individual creation to each person who took part to the creation of the work. So in this situation, for collective work, there is a presumption of ownership in favor of the person who disclosed the work. So type of work which will affect also which has an influence on the ownership of the copyright, a composite work, derivative work, which is based on a pre-existing work for which there is a different author, but the composite work is made without the collaboration of this first author. So in this situation, the ownership of the copyright on the composite work is for the author who made this second work, but it is dependent on the authorization on the copyright ownership of the pre-existing work for the author of this pre-existing work. So there needs, as you can see, there needs to be an agreement here. Exceptions according to the type of work. For software, for the source code of software and the documentation relating to software, when it is made under the duties of the working agreement or under the instructions of the employer, then automatically ownership of the copyright is for the employer. Another exception is according to the type of employee in the very specific situation of civil servants working for the French state. When they created something, the French state has the possibility to exploit that work and therefore to get the right to use that work in a specific situation that is the fulfillment of a public service mission. If use of the work is outside this very specific situation, then the civil servant remains the owner of the copyright. Because of these principles and limited exceptions, we need to have agreements for the transfer of ownership of copyright. So in such agreements, there is also one very strong principle, that is that global assignment of all future works is void. You cannot have an agreement that says, I transfer all my future work to my employer. You have to be more subtle in the wording of such clause. You need also to have written evidence of contracts. That doesn't mean that you need to have a written contract in each and every situation. It is, of course, better, but in some litigation, you can use a detailed invoice, for example. You can provide evidence such as exchanges of emails when they are sufficiently precise. And in some very specific situation for specific type of creations like audio-visual works, you absolutely need a written contract. So it's better to have a written contract, and it is required to have written evidence. And also in agreements, you need to be very precise regarding the scope of the rights which are being transferred. When I mean the scope, I mean the extent, purpose, place, duration, but you should also consider listing the media on which the work will be used. An important part of any agreement is the price. And in French law, for copyright, the principle is royalties, a proportional remuneration according to the success of the sale or exploitation of the work, a percentage of these revenues. And of course, next to the principles are exceptions. You can have a price which will be a flat fee when it is very difficult to calculate the portion of the revenue of exploitation. It is also possible to have a flat fee when the author contribution to what is being exploited as a commercial object is only a very small portion. So if the author contribution is very small, then you can pay the author with a flat fee. And the assignment of copyright over software can be also made with a flat fee. To close with this section, I have some very basic recommendations. It is in the employer's interest to create evidence and to create a situation where the qualification of the work will be a collective work, because the employer will be the entity releasing the work, and then therefore the presumption of ownership will play in favor of this publisher, of which is supposed to be the employer also. So you need to provide instructions to have a certain organization of the creation that will be in your favor so that you can claim it is actually a collective work. Next is also a very simple recommendation. Audit your contracts, know what is inside your contract, know the exact list of your contract. Then in agreements, be very precise regarding the wording of such agreements. When setting a flat fee for the price, mention a justification for that. Mention that it is difficult to calculate a percentage of the revenue. And also regarding the price, it is recommended to isolate the component of the price which only relates to copyright transfer. If the contract is more complex than just copyright transfer, it is absolutely necessary to isolate the component of the price which relates to transfer of copyright ownership. So that's all for the first section. Next is design law. That will be shorter and more simple. In France, we have two different types of design registration which can be enforced. First, the European Union designs, which are governed by a European Union regulation. And in this regulation, Article 14 states that a design which was executed within the duty of an employment contract belongs to the employer. Very simple solution, except if the national law or if a specific agreements say differently. Then for national design registrations, the current French law states that the design rights belong to the creator. That will change in the very near future because last year we had a reform called the design package, which will force member states to align with what we have for European Union designs. So in other words, in the very near future, the French law will change so that the employer is directly the owner of the creation of his employee, as far as design law is concerned. Then, final section for patents, we have specific rules for the ownership of patents of inventions created by employees. We've got three different situations, and I will only list two of them. The first situation listed here is what we call mission inventions. These are inventions which actually fit the mission of the employee. The working agreement mentions a specific mission of invention, mentions duties of invention, research in a specific field. So if the invention fits into this scope, then the invention will belong to the employer. Next on the right, we have what we call SORI, so word-for-word translation, attributable non-mentioned inventions. These are inventions which are created using means of the company, like the knowledge, the data, the techniques, the technical means which are specific to the company, but it's not actually an invention that would exactly fit as a mentioned invention. So for both of situations, there needs to be some specific additional remuneration in favor of the inventor. And also I mentioned that we have set in France a conciliation commission, which facilitates the resolution of any disputes in this field. Sorry, before I move to the next slide, I mentioned that there were 3 types of invention, and the third type would be invention that do not fit in any of these 2 categories. So if the third type is personal invention, then there's no question the ownership of the invention stays in the hand of the employee. How does it work practically? The employee has the obligation to declare his invention to his employer immediately. And in this written declaration, he must mention whether he thinks it is a mentioned invention, non-mission, but attributable invention, or anything else. Then the employer has 2 months in order to take a decision to either admit what the inventor, what the employee declared, or simply if the employer doesn't timely answer, the proposition of the employee is supposed to be accepted. And also the employer may have a different opinion and consider that the invention is a mission invention. And he must also declare that within 2 months. Then, if in the very specific situation where the employer decides, considers that it's an attributable non-mentioned invention, the employer has 2 more months in order to claim because it is an option for the employer to claim ownership of such invention. So I hope I'm not over time, and I've got some very quick takeaway points. To summarize, copyright law is in favor of individual creator, except for software, where there's an important exception in favor of the employer. Ownership of co-ownership may depend on the nature of the work, on the process of creation. For designs, you have a principle for EU designs, that is the rights of the designs belong to the employer, and that will soon be the same solution for national design in France. And for patents, we have different categories of invention according to the very specific mission listed in the working contract, and the employer may claim attributable non-mission invention. And I do hope I didn't go beyond the 15 minutes.
Well, thank you so much, Ferdik. You are perfectly on time. So I really appreciate that. Thank you so much. It was very, very interesting presentation. I feel so sad that I put the rules of the housekeeping that all the questions will be later, because I have a very urgent question, but I'll hold it to the next session. So thank you so much. And by this, we move now to our next distinguished speaker, one of my favorite colleagues in the UAE, Dr. Hamid Abdelati. Dr. Hamid, I know that many people know you, but I still have to do this introduction, and you always miss to send one important fact about you when you share your profile. So I will highlight this part of the missing profile that you sent. Dr. Ahmed is a senior IP consultant at Axiom Mark Group in UAE. He's a very frequent lecturer in many scientific associations and academies in GCC, Egypt, and MENA region. He's a board member of AIPPI UAE chapter, and he's a board member of Scientific Intellectual Property Association, SIPA. He's a member of many IP associations, including Emirates IP Association and a lot of other ones. And he was the one who started, and this is the missing part, Dr. Hamida, he started the first IP podcast in the region. And this podcast maybe could be 6 months back, but it handled all topics of IP in Arabic and English. And I would really like to be in this podcast one day with you, Dr. Hamida. Thank you so much. So without further ado, please, we're looking forward to hear what you have to say, and the floor is yours.
Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you, my dear friend Mu'tasim, for your introduction. I appreciate that. And I would like to thank the organizers for today's event, AIPPI, Brand Protection Group, Ministry of Economy, EPA, French Embassy, all the organizers. Thank you so much. And I know that we have a very short, limited time, so I will try to make it fast. I wish that now it's okay with you. So I know that I have 15 minutes. I will try to make it fast. And thank you, my colleague Frederick, for your great presentation. And you touched a lot of points. I will try to make it short for you. As you know that, as our colleague Sarah in the introduction said that in today's age, digital age, the work environment is encouraging a lot of people, a lot of employees to have a lot of new inventions, new creations, and this is a very critical and debatable issue. And if you want to discuss in details, we need hours to discuss it. But today we'll just shed the light on the most critical points regarding the ownership of creations in the workplace. So in most countries, we have a general rule. We have a general rule for the ownership of creations in the workplace. The general rule says that the employer owns the IP rights to creations made by employees during the course of their employment. This is a general rule. Why like that? Because the employer has hired the employee to perform specific tasks and duties, and the creation of new ideas and innovation is often seen as part of the employee's job responsibility. So this is the basic rule, general rule, that whatever creations made during the course of the employment, the employer has the right to get the economical rights for these creations. Of course, this general rule and any rule has some exceptions. And the most common exceptions for this rule is that if the employee has a separate agreement with the employer regarding the ownership of IP rights, like when I'm hired with someone, I will sign an agreement stating who will have the rights for these creations. Maybe they will put the employee has a right or the employer. So the agreement is very important. If there is agreement stating that the employee has a right, then the employee will have the right. Otherwise, the employer will have the right for that. Or if the creation is made outside of work hours, I did it at home using my own material, using my own resources, then the employee should have the economic rights for his creation. Without the use of company resources, the employee may retain ownership of IP rights. These are the exceptions for the general rule. And of course, when we are talking about the IP creations in the workplace, we are talking about the economic rights, the economic or financial rights. We are not talking about the moral rights, because in all cases, there is a basic rule that the moral right to the author or the creator of the work, as they cannot be assigned to any other third party. So in any case, the creator, the employee, will have the moral rights. Moral rights means his name should appear as the creator of the work, regardless of the economic or the financial rights. So this is a general rule and the exceptions to it. Moving on to types of employment contracts. And I consider the employment contract and the agreement between the employer and the employee the turning point in deciding who has the right. We have employment agreements. These contracts typically specify the terms and conditions of employment, including ownership of IP rights. And now most countries in their employment agreements will have some articles related to intellectual property rights, who is the owner, who will have the financial rights, and companies now also started to learn from their mistakes. Then we have the non-disclosure agreements. These contracts require employees not to disclose any confidential information to the public during their course of employment with the company. And the last one is the assignment agreements. These contracts require employees to assign ownership of any IP rights they develop while working for the company to the employer. So these are the most related contracts related to IP rights, employment agreements, and all its articles, then non-disclosure agreements and assignment agreements. If these agreements exist, it will have the upper hand in deciding who has the right for the creations. Then, what is the UAE law and practice? As we are here in UAE, and I think most of the Middle Eastern countries have the same one, but I will shed the light on the copyright law that was issued in 2021. And it has a separate article regarding the author's economic rights in his relation with third parties. This is very important, and it's very critical, and it's very decisive also. Here we have three things. We have three parts. If an author creates a work for the benefit of another person, the copyright belongs to the person whose favor it was made. For example, I have a company, then I have a contract with some software company to develop some software for me, for my use. Then this ownership of the copyright or the whatever the creation, it will belong to me because I have paid for them. I have hired them to do some kind of freelance work or something. Then it's my ownership. They will have the moral rights for the work, but the financial and the economic rights, it will be for the person who asked for it. The second part regarding the what we discussed in the general rule, that if an employee or worker during his employment creates a work related to, related to the activities or business of the employer that is directly or indirectly mandated or instructed by the employer, or uses to reach the creation of such work, the experience or information or tools or machines or materials of the employer, then the economic rights shall be for the employer. And this is very important here because it is stated by the law that if any employee created any work during his course of employment using the company resources, experience, tools, machines, or whatever, then all economic rights shall be for the employer, taking into account the intellectual effort of the worker. Intellectual effort means he will have the moral rights that his name will appear in the work as a creator of the work. And of course, maybe some companies will compensate the creators or the employees if they have created a very important creation for them or invention or whatever, and the company gets some kind of profits or benefits for it. Maybe some companies can pay for that. But the basic rule is that they will keep the moral rights. And the last one is if employee creates a work that is not related to the employer's business and doesn't use the employer's experience or information or tools or raw materials to reach this innovation, then the author's economic rights shall attribute to the employee or worker. So if you can see, this article number 28 in the copyright UAE law covers all the three debatable areas regarding who owns the work. The last one related to if I am a worker and I did something in my home without using the company information, the company tools, the company resources, then I am the owner of the work. This is regarding the UAE law and practice. We have also another one for UAE Patent Office. And when we say UAE Patent Office, patent covers patent and industrial design, utility models, all related to one department. Many of you know that we have three requirements to be added to the filing documents: the power of attorney, the deed of assignment, and the certificate of incorporation of the applicant. And I will just concentrate on the deed of assignment part. If you see, in front of the deed of assignment, they mentioned that this is a regulation of the UAE Patent Office. UAE company may submit a certificate of employment or copy or employment contract, copy of employment contract as an alternative of deed of assignment. So in order to file the patent application or the industrial design or authority model, if I don't have a deed of assignment from the creator, that he assigns his rights to his employer or his company, whatever, we can submit a certificate of employment or a copy of employment contract as an alternative to the deed of assignment. Why like that? Because it's mentioned here, if the inventor is the employee of that company, since the invention of an employee is automatically transferred to the employer under UAE IP law. So now they consider that if employee created something, automatically it will go to the employee if they don't have a separate agreement for the rights. This is a practice of UAE. It's very important also. Then coming to the best practices for employers. I have a company, I have some people working with me. What should I do to avoid disputes over IP rights? To make it very clear. First, we should have clear IP policies. To develop clear policies and procedures for handling IP rights, including ownership and use of creations. And I think in the digital age recently, many companies started to have IP policies stating that who have the rights and also some contracts with the employees. Then educate employees on IP rights and their responsibilities regarding creations made during work hours. We should teach them if they have any doubts who will be the owner, otherwise some misunderstanding will be there. Then they should review contracts. The companies should review contracts, employment contracts and agreements to ensure that they include key provisions regarding IP rights. These are the three steps, main steps that all employers should do in order to avoid any disputes related to, and we will see why this is very important in the last slide. Then, I am an employee working for one company. What should I do in order to avoid this kind of disputes? Number one, understand employment contracts. I should revise my employment contract, understand its articles in full, and especially any article related to IP rights. I should be aware of that. I am the owner, they are the owner. I will be paid or not, so I can keep everything settled. Then keep records. This is very important. Any employee who creates these kind of works should keep records of their creations, including dates, times, and description of their work for future. For anything happen in the future, they should have all the records. Number three, this is very important, seek advice. If you have to sign any agreement, you should seek advice from a lawyer or any other expert if the employee has any questions or concerns about IP rights. And this is very, very important to understand. We have many cases. I have many cases actually, but I just selected one case in India in this regard between the Indian Performing Rights Society, LTD, against Sanjay Dalia. This is a very famous case happened a few years ago in India. And the Delhi High Court decided that on an issue of copyright ownership related to musical works generated by some employees. The company filed a case against the employee seeking or requesting the ownership of this work, but the court determined that the employer doesn't have copyright or ownership over works created by employees while they are employed, unless specifically stated otherwise in an employment contract. And this is the importance of agreements or employment contract, even if there is a law, even if there is some kind of regulation, but the agreement between the employee and the employer is very, very important, because maybe the court will take another direction, maybe the court decides. So any agreement between the two parties will be very important and will be very decisive in deciding who has the ownership. So now the court decided that if the employment contract doesn't have a specific article deciding who is the owner of the creation, then the employer doesn't have direct or automatic ownership over the work. I think I did it very fast for you. I know we have very short time. And the conclusion, we can summarize what we said in the whole slides, that the employer should protect their interests and their rights in signing agreements with the employees, and they should have specific and decisive and very clear and straightforward articles related to IP rights, IP creations with their employees. And on the other hand, also employees should consider their employment. Don't sign anything without reading it in a proper way, without deciding, without checking with an expert, taking the opinion of an expert in order to avoid any future disputes over IP rights for creations made during the course of employment. I hope I did not take more time, and thank you very much.
Thank you so much, Doctor. Exactly, again, on time. I'm very proud, very shocked. You both are totally on time. So thank you. Please, if there is any question, you can either ask to take the mic, or you can put them on the chat. From my side, I want to start with one important question for both of you, please. Now, obviously, the French system and the UAE system is not exactly the same. So if you have a client, what would you recommend to your client to do in terms of mentioning anything related to IP rights in the employment contract? Obviously, the options are either it's mentioned in the employment contract, or we follow the local laws and regulation, whatever it is in this country. If it's your freedom to advise a client whether to mention this in a contract or leave it and let the laws handle any updates or development, what would you recommend to them? So this is for both of you, please.
For me, Mr. Frederick, you want to start?
Please go ahead.
Yes, for me, I always prefer clear-cut and straightforward agreement, separate agreement between the two parties, deciding who will have the ownership of the IP rights. Because as you know, we have some kind of interpretation to law in different opinion. Maybe the judge or the lawyer or the jury, whoever is considering the dispute, maybe will have different opinion. But if there is a specific and straightforward and clear-cut agreement between the two parties, of course, it will be considered by the court or by the parties when considering the IP rights. This is as per my opinion. Even if there is a law, even if there is an article in the law stating who should have the ownership, but agreement is very, very important. And we see in the Indian case that I mentioned, the court decided that if the ownership is not mentioned in the agreement, then it will the employer shouldn't have direct ownership of the work.
Thank you, Doctor. Frederic?
Basically, for me, the precision and existence of an agreement is absolutely crucial. As we've seen, we've got different systems in as far as copyright is concerned, and the more precise you are in agreements, the safer it is for any parties in order to prevent risk of disputes. So I will only have this very basic recommendation.
Thank you so much. We have two questions. Madame Huda, please, and then Ms. Ghada. Yeah.
Thank you very much, Mu'tasim, and thank you to both our speakers. Fantastic, very, very informative. If I could just ask Frederick, you touched on a French Conciliation Commission. Could you just explain a little bit more what they do, how someone would file a complaint, or when they would file a complaint with them? Just give us a little bit more detail, because I think that's for us that would be a best practice learning.
Okay, thank you. So the Commission only deals with disputes over patent ownership or mostly remuneration. This commission can be seized whenever there is a dispute when an employee or employer do not agree on the process of the declaration I mentioned on one of my slides, when the employee has to declare his invention to the employer, and then the employer has 2 months in order to take possession. if the position of the employer doesn't match with the position of the employee, then there's a risk of dispute, and they can either party can seize the commission. This commission will mostly state who owns the invention right, and also will have, in some situation, the duty to determine the fair price for the remuneration, which could be either royalties, which could be a flat fee, or which in most situations is a mix of the two.
Thank you, but just to make sure we understand completely, who set up this commission and who are the members of this commission? Because you're saying clearly they're assessing the value of something.
The commission is independent, and it is under the organization of ENP, the office.
Okay, thank you very much.
You're welcome.
Thank you, Madam Huda. Ms. Ghada, would you like to speak, please?
Thank you so much. First of all, Ramadan Kareem to everybody fasting. Thank you, Mu'tasim, for the introduction, and Frédéric and Dr. Hamida for this informative session. I'm not sure my question would relate. Most probably, Dr. Hamida, you can answer me. But I was wondering, because as Frederick has explained, I am under the impression that in Europe, for example, the rights, like basically there are measures taken to secure or, secure the employer. Are we moving into that direction in the Middle East, or are we, because I feel like in the Middle East, the employees' rights are basically more protected in that sense for any IP creations.
Actually, I did not get your point. Can you rephrase the question again?
Yes. What I understand from Frédéric is basically in Europe, they are implementing measures to secure the employer in terms of the employee creations. Are we going into that route here in the Middle East anytime soon? Do you anticipate this?
Yes, I think with the current aid that a lot of creations happen now in the many companies, and I think UAE already started. UAE, if you heard what I said regarding the copyright law, the article that I mentioned, they put a general rule that if any creation happened during the course of employment using the company resource and all, automatically the employer will be the owner of the economic rights and financial rights. And not only UAE, I think many countries in the Middle East has the same rule that the employer should have the economic rights for any creations happened during the course of employment. What will decide if they have a separate agreement or separate contract related to ownership of IP rights. So I think Middle East countries also, they are following the same route as Europe in many countries, specifically that if it goes to the court, it's something else. Maybe in the court, as you know, in the court, they have different interpretations of the laws and some kind of cases and some kind of opinions. But as per the law, it's there. And as I mentioned in my presentation, that the agreement between the two parties is very important. So the companies should have their own agreement together with the law. Law only is not, I think it's not sufficient, but in order to avoid any dispute, they should have a separate agreement deciding who is the owner of the work.
Okay, thank you.
Thank you, Ms. Ghada. I have one more question, if you don't mind. Please, Frédéric, from your experience, in case of any dispute, what's the process of resolving dispute between the employer and the employee whenever there is ambiguity in the contract, or whenever it's not clear who created or what's the group of people who created? How does it happen in French companies or system, or what can we do? in case of any disagreement or dispute?
Like many disputes, it may start with a formal cease-and desist letter, and which may start a discussion, which may start a direct negotiation. And then if there's no agreement, except for patents where there's this commission which may provide a solution quickly and efficiently, we have to go to court. And then the scope of the agreement, precision of the agreement, if there is one, will be discussed. Or disputes are handled, that would be possible negotiation, but it's not mandatory, and then go to court.
Understand. Thank you. Madam Huda, please.
Thank you, Mu'tasim. If you'll allow me to ask a second question. So, as with many things, the law doesn't always catch up with reality. So it's always kind of running to keep up to pace. After COVID, of course, a lot of companies are still actually online. So are you finding it a challenge? And this is a question to both you and Dr. Hamida, actually. Is it a challenge today to differentiate clearly what work is done as during your time as a company at the company during working hours or after? Because if someone's working from home, they can say, well, I did this, while I was in my home. This wasn't during my working hours. So is this adding a new twist and kind of complication, making it a bit more messy? I'll pose it to both of you, please.
Yes, for me, it will make the issue more complicated. What you said, that people working online, how we can decide when and how they created the work. And another critical point is that if this creation related or unrelated to the company activity. This is the two challenges that makes the issue more complicated. And I think it will take, if there is any kind of dispute, it will be very difficult for all the parties to prove. And again, the role of the agreement between the two parties will play a very pivotal role deciding and helping the judge or the expert or the arbitrators or the mediators, whoever is handling the dispute. And it's very complicated. I want to hear from Mr. Frederick.
Thank you. Very interesting question. On my side, I would think it may provide more security in the sense that working from home means that you are online. You are using a computer and you are therefore exchanging with your colleagues by emails. These emails are pieces of evidence. So I think they are very interesting for copyright ownership insofar as they may help to prove that the creation is a collective work rather than individual or collaborative work. The fact that we have these online exchanges and that written evidence is kept of the nature and the content and date of the exchanges may be a key point which will secure employers. And also a second point which I think may favor employers as far as remote work is concerned is the fact that most of the time the technical means are provided by the employer. The computer is provided by the employer. And in some companies also you have a tracking system on the computer. You have, for example, as lawyers, we have to enter our time in a timesheet for any file we work on, and there are comparable system in other companies where you track what an employee does at a certain time. So I think it provides in some way more control for the employer, and maybe it could be safer.
Thank you.
Okay.
Hello, this is Maxence from MF Brands Group. I have somehow the same question regarding the territoriality and more specifically regarding copyright. If someone creates a work in another country, whereas he is employed by a company that is in another country or working remotely, how does it work?
Do you mean with the complexity of the French law? I would say that there's one working agreement or one main working agreement, and that should be the reference. But also the nationality of the creator is playing a strong part. One text we didn't touch and mention is the Berne Convention, which provides another level of complexity or provides some solution, but also provides a level of complexity in this regard. And just to avoid the complexity of your question, I would say this convention exists and we are running out of time. I don't want to enter into details.
Yeah, I'm aware this is a complex question, but just as there are new ways of working remotely and away, something that came to my mind. But thank you very much for your answer.
You're welcome.
Thank you, Maxine. And Nevin, do you still want to ask? We have exactly 3 more minutes. I saw you raising your hand.
I raised my hand, and looking at the time, I thought I will put that question separately. But then now that I've asked, it's one comment and one question. One question is to all the participants here. Do we have, like, especially from the UAE perspectives, do we have any active case or past cases related to this, like employer-employer relationship or anything that you're aware of? You could either post it in the group later. I would love to read that case because, and that leads to my second comment, wherein we had probably soon after pandemic, there was an issue with one of the biggest university and the employer where they did not have a legal agreement or a contract. It was a basic research, and during the commercialization, at the time of commercialization, then the dispute arose. Obviously, the university had a bigger hand. A lot of know-how was shared in between these. So I agree with both the speakers where a typical contract needs to be there in place. Everything would be glitz and gams at the time of research when it comes in picture, when money is involved. But soon after, when there is a major development and when there is a patent or a design or an invention in place, that's when the dispute arose. And long story short, with the case that we were handling, they had to settle it out. The university then agreed about 70-30% of the share because there were clear agreement that the university was not willing to commercialize it. When there was a clear indication that the university was not ready to commercialize, that's when the inventor commercialized it, right? So those kind of issues can arise. So I was just trying to share my experience, but then I would still love to hear if there is any case laws that any of the lawyers here is aware of, especially from the UAE perspectives.
Thank you so much, Nevin. Always valuable contribution from your side. We really appreciate the input. And if there is anything you can post or send by email, please let us know. I have less than 1 minute to move back to Sarah before I end. I want to say thank you very much for our speakers and for the participant. تقبل الله صيامكم وقيامكم وصالح أعمالكم وجعل الله أيام صومكم رحمة ومغفرة. Thank you so much, and Sarah, this is back to you.
Well, thank you, Matasim, for this great discussion, and thanks to our speakers for the great presentations. We really learned a lot from you today, and thanks to the participants for the questions. It was really a very interesting discussion, and I hope to see you soon for another webinar. So thank you all, and have a nice day.
Right on time. Thank you, everyone.
Thank you.
Thank you very much.
Thank you very much, everyone.
Goodbye.